Alexandra Dunn is Executive Director and General Counsel, Association of State and Interstate Water Pollution Control Administrators. And Erin Flannery is a federal government water attorney. So welcome and thank you.
Great. Well, it's wonderful to see you all. And hello to everyone on the phone and on the web. So I'm Alex Dunn, and my organization goes by ASWPCA, which is a lot easier than saying the full name. But bottom line, we are the association of all 50 state water officials. So we would represent the top official in each state for water quality, surface water quality. There's a similar organization that would handle drinking water. There's another organization that handles groundwater. And I've already just alluded to the fact that water is a very fractured resource in terms of how we manage it and how we handle its quality and protection. So you'll get a feel for that, I think, as you hear us talk today. How I got to where I am today is interesting. I graduated law school here at Catholic Law in '94. I was interested in environmental law back then. I interned at DOJ. I heard we have someone at ENRD, a PACE student as well. And then I went on, I joined a large law firm, started out there and decided DC was too much fun to be in a big firm, although for any of you in big firms, I learned a whole lot there and I'm still great friends with the partners that I worked with. But I decided public policy was more what I wanted to do. I went and joined, you could say, a very challenging organization, the Chemical Manufacturers Organization. So I worked with major chemical companies in the U.S. on clean air, on Superfund, and on environmental justice. I did not do water, but then my next job I worked with an association of city water officials on water and sewer issues, and that's how I became a water lawyer and spent 7 years doing water. Then tried my hand at academia, moved up to New York, and was the Dean of Environmental Law at Pace Law School for 3.5 years from '07 till last fall. Unfortunately, New York fit me well, but not my family, so we decided to come back to Washington, and I'm the Executive Director and General Counsel of ASWPCA now. So back in water, back in policy, back in DC. Love New York, but that might give you an idea of how I met Ms. Flannery, my co-speaker. So I will turn it to Erin to introduce herself.
Thank you so much. Good afternoon, everyone. My name is Erin Flannery, and indeed, I am a federal government water attorney. I work for the U.S. EPA, and all my remarks today are my own. I'm doing this on my own time, and my remarks don't represent the positions of EPA. That said, I did attend Pace University School of Law, where I met Alex, and where I was fortunate enough to take her environmental justice class, which was just outstanding. I graduated in 2009. During law school, I interned at NOAA's Office of General Counsel for Fisheries and NRDC's Oceans team in New York City. And I also worked for the Hudson Riverkeeper through the Pace Environmental Litigation Clinic. I came to Washington and to EPA in September of 2009 as a legal fellow in EPA's Office of Wetlands, Oceans, and Watersheds. And the fellowship, in case you're interested in ever applying for one if you're still in law school, it's called the ORISE Fellowship for the Oak Ridge Institute of Science and Education, one of the national labs that administers that program. So I worked in the 404 regulatory program, and in March joined the Office of Wastewater Management at EPA in the NIPD's 402 permitting program as an attorney. So I'm thrilled to be here today and to tell you about some exciting Clean Water Act cases and hot topics right now, following Alex's introduction to the Clean Water Act itself. And we hope to explain to you and show you why we think that the Clean Water Act is a pretty great thing to work with.
Yeah, no, I agree. It's, as you heard, I worked in Superfund, and every lawyer, every practitioner, and many of you may be policy people. So just to get a feel, how many of you are on a legal track per se? Okay, and how many would you say public policy, sort of environmental policy? Great. So that's a typical Washington crowd, right? And I think most of us that practice environmental law in Washington are really practicing a combination of legislative policy, public policy, and environmental policy all mixed together. It's sort of non-traditional law, at least in a lot of senses. And most of us are pretty excited about the laws we worked on. When I was an air lawyer, I thought there was nothing more exciting than air quality. But I have to say, I think water's where it's at. So let me tell you a little bit why. So here we are. The Clean Water Act is actually going to be 40 years old next year. It was passed, the law that we call the Clean Water Act that we know of today was passed essentially in '72. There were predecessors. And yet here we are 40 years later, certainly, you know, half a lifetime for a human generally, and we're still not done. You know, we still have enormous water quality challenges around the country. And if you ask people, public polling, what they worry about and do they think the water's clean, most people will say they actually think it's not good and getting worse. So it's the general public perception is that things really haven't gotten better. The reality is they actually have, but trying to convey to people what we need to do to keep the progress we've made and not slide back, and then to keep making more progress in some really complicated areas that we'll talk about, like the Chesapeake Bay, the Mississippi, the flooding issues that you're hearing about on the news, and all of that. I mean, water is sort of so present in the news and in people's perceptions that the perception is it's just not good. Administrator Jackson at EPA has made water a top priority. She comes from New Orleans. She's lived somewhere where the co-opting essentially of the wetlands led to, you know, some pretty awful devastation in that city, and she's been in the Gulf area where we had the Deepwater Horizon. So, you know, we've got our challenges. So very quickly, what I'll do today with Erin is just give you a flavor of the history of the law, its major provisions. We can't teach you the whole Clean Water Act in an hour plus, but I think you'll get a good flavor of its structure, and then some current issues. Not going to walk you through this one, but for those of you who print this out later, you should know that, you know, there was a lot of history on water, but some of those early statutes, 1948 and so forth, really had to do with commerce and keeping the waterways open for navigation. Keeping large trees, and, you know, we still do, you know, float trees down to timber mills, you know, keeping it so that people could actually use the water for commerce. And when you remember, you have to remember, and I know it's been drilled into Erin's head, the authority of the Clean Water Act is based on the Commerce Clause of the Constitution, right? So that's, when you hear about some of the current controversies that we're facing today, it's that balance between the authority for federal law, which is interstate commerce. That's what the Clean Water Act is based on. And how do we connect some of these current problems that we're dealing with to this concept of interstate commerce, and maybe what Congress thought they were trying to do when they were addressing navigable waters in 1972. So I'm always going to pause and look at Erin in case she wants to jump in.
I think that's excellent. And I also, whenever I think about how we derive the authority for the Clean Water Act, and how Congress looked initially to see the broadest extent of the Commerce Clause, I think it's always interesting to think about how in the United States, there's nothing in our Constitution that directly says that we have a right to a clean environment, so we have to go looking for the Commerce Clause. Other countries, such as Brazil, have in their very Constitution that everyone has the right to a clean environment, and so it's easier to derive environmental laws there. And we have to dig a little bit farther, and sometimes that leads to some tenuous interpretations of what interstate commerce is, which can lead to challenges in protecting those waters.
Mm-hmm. Absolutely. So what I like to say is is the heart of the statute, which was a pretty bold goal. And if you just read that, wow, Congress did not give us a small task here. Restore and maintain the chemical, physical, and biological integrity of the nation's waters by a variety of ways, but including eliminating the discharge of pollutants, and I put without permits, into the navigable waters of the U.S. So right there, navigable waters, which we're going to talk about a lot today, is right up there. That was the goal. But so we have to know what a navigable water is, and you'll hear that we're having a little trouble figuring that out 40 years later. Also, I like to say about the Clean Water Act, it sort of sets up this strange paradox, right? We want to restore, the waters, and yet this very statute to restore waters creates a permit program to put things into the waters. So there's a little bit of a dichotomy, and many people say the Clean Water Act is a failure because it hasn't eliminated discharges to the waters of the U.S. There's still pollutants going into the water, they are controlled by permits, they're limited by permits, but the act in and of itself set up, I think, two concepts that were sort of in conflict with one another. Okay. Just in short order, the statute has been amended several times. Largely, it had to do with money. When the statute was passed, we had pretty bad sewage problems in this country. Many of you know the story of the Cuyahoga River, which was on fire in Ohio. Lake Erie was dead. I mean, there was just low-hanging fruit. It was so bad. And so when the Clean Water Act was passed, it was actually passed over presidential veto. Many of you will hear that President Nixon vetoed, the Clean Water Act, and it showed that he was really an anti-environmentalist. But regardless of your feelings on President Nixon, the reality was he objected to it because it cost so much, and he was a fiscal conservative, and he said he wasn't anti-clean water, he was anti-big bucks. And this statute came with a lot of money to communities to upgrade their sewage treatment. And it made us, put us in a whole different place in terms of a first world nation, in terms of the water treatment that we have today. Still have problems in that area too. I think I'm going to skip over some of these things because I think we've got too much to say about the current. But, if you want to go back in the past, this will give you some ideas. I've mentioned about the grant program. There were grants initially. The money that went, that President Nixon was so concerned about, was money straight out to communities. We now have something called a loan program. You might hear something called the SRF, the State Revolving Loan Program. It is the biggest line item in EPA's budget. It is basically a revolving fund that makes low-interest loans to communities to invest in wastewater treatment. We also, over time, have focused on control of toxics versus control of sort of more traditional pollutants. And then in 1987, the biggest and most important amendment in 1987 is number 4 there, which was nonpoint source, a program for dealing with stormwater, which is a hot issue today. So 87 was when we amended the statute. So imagine all those years from 72 to 87, we weren't even focusing on stormwater, non-point sources, and we'll explain point, non-point in a second. But this was sort of a gap in the initial statute that wasn't picked up until 87. All right. What I like to say about this is just remember the statute has continued to be amended, but in ways that if you look at these, what jumps out at you about them, the names of them? Geographically specific, right. So the amendments to date have been much more focused on specific water bodies, and I think that's because it's a lot easier to get something like that through Congress today than anything big and broad that would change the act fundamentally. Okay, so let me give you just a quick primer. I'm going to tell you about 3 Ps and 4 Rs. Okay, so prohibition. This is where the tension in the law begins, right? The statute has a prohibition. Any discharge of pollutants from a point source to navigable waters is prohibited. If the sentence stopped there, we'd have a very different law. But we don't. We have the comma except as permitted, permitted, permitted. Either way, it's a permit and it's permitting something. Some people say it's a permit to pollute. But bottom line is, you can't put a pollutant into a navigable water from a point source without a permit. Now, we'll talk later about the states that are authorized to administer this permitting program. This is the program in which Erin now works. The reason there's bold there, discharge, pollutants, point source, navigable waters, those are all terms of art in the statute. They're all defined, and we'll talk a little bit about that.
And all heavily litigated.
Yes. Yeah. Plain English in this statute, it just doesn't get you there. Okay. Discharge. Discharge has been litigated. What is a discharge? To the point that we have had to even litigate the definition of discharge, which is any addition of a pollutant. What does it mean to add a pollutant? So here's a great example. I have these 2 water bodies. I transfer with a pump some water from here to here. I've done nothing except move it. Have I added something? Some courts say yes, some courts say no. Have I added a pollutant? What if the water is exactly the same? Have I added a pollutant? There might be something in this water that's not in this water, right? So we've had to litigate what it means to add a pollutant. And there have been cases involving water transfers, just moving water from Colorado down, from parts of the Everglades over.
From one water body in New York to a very close by water body in New York.
Right. And what the Supreme Court has basically left us with in a case called Miccosukee is if you're pumping between two, if you're moving water between two discrete water bodies, you are adding. If you're pumping within a single water body, you're not adding. In the Everglades case that reached the court, they didn't know anymore if it was a single water body or two, because the landscape had been so dramatically altered that they had to remand it to the lower court to determine if we were still talking about a single water body or separate. Okay, pollutant. Well, we should all know what a pollutant is, right? Again, that one's been litigated too. And the important thing to note about pollutants, what jumps out at you from this definition that might surprise you as being a pollutant under the Clean Water Act? Sand. Why does it surprise you? Right? There's another one. Heat. Who said that? Yeah. Temperature. Temperature is a pollutant. Why? Because we're talking about ecosystems, right? If you have a cold water fishery, anyone likes to trout fish in here? You don't want it too warm. Yeah, right? So if there's an industrial facility that's putting warm water from its treatment plant into that trout stream, you're going to disrupt the biology, and it's going to be a problem. And lots of us like to ask about cellar dirt. I've yet to find out what cellar dirt actually is.
That confuses us too.
Okay. Point source. I always like to say it's what you can point to, right? It's a pipe, it's a conveyance, it's a channel. You can point to a point source. You can say, here's where the pollution is coming out. A non-point source, think of it broad, like farmland, where the water and the pollution is running off from a wide area. You can't really point to the one place where it's coming from. That helps me. Discernible, confined, discrete conveyance. Includes, however, some new things. Vessels. A vessel that might be out at sea and come in with ballast water. That is a point source because you're discharging from, I guess, a part of that ship. That's a new interpretation.
And introducing pollutants, like different organisms that were native to the water the port where you came from, and then you discharge them into a new area and cause all sorts of invasive species problems. Huge problem in the Great Lakes and other parts of the country.
Yeah, absolutely. CAFOs, a new one. I mean, the law, we are still making big changes. Consolidated, it should be consolidated, it could be concentrated. Consolidated animal feeding operations, CAFOs, large. Are any of you with agricultural groups or working on ag issues? Okay, so you put a whole lot of chickens or pigs or cows in an area, it's not pretty, And what comes out ends up, affecting water quality. So just in the past, I think 5 years, we've come up with a permit program for CAFOs. So the program is growing. So I give you this to show you the types of things that are point sources. We went from the early days where it was a factory and that pipe and that, kind of really obvious thing as a point source, to now, I mentioned the CAFOs, forest roads. Erin will talk about how forest roads are now being looked at as a point source. The salmon is meant to represent aquaculture. Do you know where we're farming, fish out in the contiguous zone to the U.S.? You probably know all about this. From, you've got fish in there and a whole lot of fish in a pen. Even though you're in the water, they're discharging from a point source.
Absolutely.
Even though you probably couldn't point to the one place in that pen where the pollution's coming from, it is. Aerial spraying of pesticides, helicopters. That is a current issue that Congress may address before October 31st. After that, if they don't take action, states will be permitting aerial spraying of pesticides over water. So The program is growing. Navigable waters, I think I'm going to go briefly here because Aaron is going to talk more about this. But we told you that navigable waters, there's a concept, and some of the legislative history is that Congress wanted the broadest definition under the Commerce Clause beyond what I mentioned before of traditionally navigable waters, you know, getting the boats down. Some people say it's anything you could float a canoe on, anything wet. Well, we'll see. Aaron, there's a lot going on. This is one of the hottest issues right now today in Washington because of a series of Supreme Court cases, and we'll talk about that. So just put that in your back pocket for later. We're going to talk about navigable waters. Okay, so permits, I've mentioned the permit program and that it is a cooperative federalism concept. So some of you who like the idea of, you know, the 50 states and the big federal government, this is one of those perfect places where you see this idea of cooperative federalism. It's what our country is sort of based on, and what most of the environmental laws in our country are based on, is the federal government sets the broad programs and guidelines, and then the states apply for delegation from EPA for these programs, and they run them in the place of the federal government using state law that mirrors federal law.
Yep, and when states apply for such programs to be authorized, they need to show that they have the proper resources to take over the program, that their regulations and statutes support them and give them the legal authority to do so, and that they have those regs that mirror federal regulations. And sometimes those programs, I think we have a map coming up of the states that are authorized. They might get their programs in phases, and the regional administrator of EPA would be communicating with the governor and would let the governor know when those different processes were through. They might get a pretreatment authorization or a general permit authorization or a biosolids program all at different times.
Most of this, there are 45 states, as Aaron mentioned, we have a map later. 45 states have delegation of the program, and they issue these what are called NPDES permits, NPDES permits. Sometimes you might hear the term SPEEDES permits. If it's a state permit, the states use a different acronym. But bottom line, it's a 5-year permit, and it controls the discharges into the navigable waters from those point sources. Do you want to mention wetlands permitting?
Sure. So Alex has just talked about Clean Water Act Section 402 permitting and how states can be authorized to take over those programs. Currently, only 2 states, New Jersey and Michigan, have 404 permitting. The 404 program is mainly administered by the U.S. Army Corps of Engineers with EPA oversight. And EPA works with the Corps as permits are developed. We'll talk a little bit more about that later, what happens when those agencies disagree on controversial permits. And so Section 404 regulates the discharge of dredged or fill material into waters of the United States. Back when we were talking about what a pollutant was, it listed a whole bunch of things. We talked about cellar dirt and sand and gravel and rock. It didn't mention fill, and so Congress left defining fill material up to the agencies, and we'll talk a little bit about that more later. But basically, fill material changes the bottom elevation of a water in the United States, or can turn it into land, depending on how much fill material there is.
Right, and part of why the states haven't administered or taken over the 404 program is that there's actually a different provision in the Clean Water Act about funding for the states, and there is no money for some reason for the states to run the 404 program. And unlike the 402 program, which comes with grants to the states to help them manage and run that program and hire staff and bring enforcement actions and do all that work, 404 does not have that. And so there is actually, if the statute were ever amended in a meaningful way, states would certainly maybe look to this as an area where there could be a change to the statute and more states would take the program. Okay, so here's the map that we alluded to, and this can be something you can look at later, but in terms of the amount of authorities that states have. It's just important to note that depending on where you are, you might be in a state where the state is the primary entity that you're dealing with, or it could be the EPA region in that part of the country. So a good example would be in New England. Massachusetts and New Hampshire do not have the program. But Vermont does. Does Vermont? Yeah, Vermont does.
Maine,
yeah,
Rhode
Vermont,
Island,
Maine,
Connecticut.
right. So even in one region of the country, you'll have this aberration where the permitting authority is EPA, US EPA, in some states, and in most states, it's the state. Okay, so the final P with the prohibition, the permits, and the penalties is just to know that there are penalties for violating the Clean Water Act. They can add up pretty quickly. There's all types of penalties. There's administrative penalties. There's civil penalties. There's even criminal penalties. I'm not going to spend a whole lot of time on that, except to let you know that periodically penalties are adjusted for inflation. I always think that's sort of interesting, because if you look at your statute and someone asks you to do some research and you open up the Clean Water Act, it will tell you that the penalty per day is $25,000. Well, if you went and did the math, you would be wrong. Say someone comes to you and says, well, how much, could my client possibly face for this violation? You'd be wrong, because you wouldn't know that the statute has been adjusted for inflation. So that's just a reminder that the devil is always in the details. Okay, so very quickly, what would a permit do? A permit would do these 4 different things. Restrict what can go into the water, require reporting. It also has reopener provisions. So when we say that they're 5-year permits, what if something changes in that 5-year period? The permit can be reopened by the authority. And the permit is not a property interest. It's not something that the entity owns. It can be taken away, okay? So doesn't happen often, but it can be. So very, very briefly, and Aaron made some good notes to me, because these pictures are actually misleading. These are pictures of a nuclear facility and a cooling water intake structure. These are the types of facilities governed by Section 319 of the Clean Water Act, which are cooling water intake structures. 316. Oh, 316, yeah. I'm sorry, 316B. But anyway, they're pictures of industrial facilities, but they're governed by a different part of the statute. Anyway, basically, there's phases of how permits are written. First, there'll be a technology. What kind of industry are you? Are you a steel manufacturing facility? Are you a paper mill? Are you a chemical manufacturing facility? You will have a technology, an effluent guideline that will be required just because of who you are. It's sort of baseline technology.
Right, and then if you're a permit writer and you then look at, okay, what is this facility going to be discharging, and you look at the water quality standards, which we'll get to in a second, you need to make sure that the facility's discharges will also be protective of water quality standards. In the event that the technology-based standards aren't strong enough, then you'll also need water quality-based standards within your permit to make sure that you're not degrading the quality of water into which you're discharging.
That's right. So think about it. Generally, you don't stop at technology in the Clean Water Act. The technology will be your baseline. You put on the gadget or gizmo that's acceptable for that industry. And then under 301B1C of the Clean Water Act, any more stringent limitation, as Aaron mentioned, would be added to ensure compliance with water quality standards. So what are water quality standards? They're written by the states and approved by EPA. And they list how a water body is to be used. So, for example, a water quality standard could talk about a cold water fishery. It could talk about primary contact recreation, meaning that people are swimming there. It could say that it is an industrial channel. And so the water quality standards might be less. But those water quality standards are really where the science hits the road in the Clean Water Act. It is designed to make sure that how we want to use those water bodies is possible. If you have algae blooms in a place that's designated as a swimming beach, you have a violation of a water quality standard. And any permit allowing a discharge into that water body is going to have to control discharges of nitrogen, phosphorus, et cetera, into that water body.
And it's very difficult to say, okay, well, we just won't swim here anymore. Once that use, that water quality standard use is developed, say for primary contact recreation, people are going to be in the water swimming, or children are going to be splashing around, you're going to have contact with that water. It's very difficult to remove that use, and you have to go through a very extensive analysis called a use attainability analysis to demonstrate that to remove that use. they make it a very high bar to maintain that water quality.
Yeah. I worked with the city of Indianapolis. Anyone from Indianapolis here? Well, there's a lot of urban streams in Indianapolis, and they're not pretty. I mean, this is like not really great neighborhoods in Indy, and you know, they're really pretty yucky areas, the kind of what you would call, like you just find a shopping cart, you know, tossed down there, a lot of concrete, but there's water there and trees. And, you know, the city would say, they would find ropes, so kids were splashing, and there was evidence of children using those waters, even though the state and the city would say we don't want people in them. If the use is there and if it's being used, then you have to protect to that use as well. You can't just say, well, we're going to put up a giant wall and tell children they can't go in there. So a lot of the tension is the cost of bringing up some of these waters to the level where people want to use them in a certain way. Yeah. Okay, now there's a third, I kind of put this as a third kind of limit that you could get in a permit, which would be a TMDL derived limit. TMDL is a total maximum daily load. Think of it as a water body that is still, despite the technology, despite additional controls on the sources, it's not getting there. It's just still, you've still got green gunk in the water. What are we going to do? The state is going to develop a total load for, say, nitrogen for that water body. And it's a pie, and there's only so much. And all of us, if we share that water body, are going to get an allocation. This much to you, this much to you, this much to you. And then that will be reflected in the permit. So the permit could have a third type of limitation that would come from the TMDL derived and built for that water body. So it's important to note, and you'll hear a lot about TMDLs because they're really important tools. But a TMDL by itself doesn't do anything. It's like a plan. It's a mathematical assessment. It doesn't mean anything until it's put into the permits in the form of some kind of limit.
Right. It's like putting your water body on a diet, basically. And it can take, you know, it can take so much stormwater from agricultural sources, or it can take so much industrial runoff, or and that balance between the waste load allocations from point sources and the load allocation from non-point sources. And then I think there's a little bit of a buffer too.
Margin of safety.
Yeah.
Yeah.
So that's really important. It kind of considers what the watershed on the whole what the watershed's contributing, both point sources and non-point sources, where it's going, and what needs to be done to protect the uses of that particular water that everything's going into.
And the challenge is that the Clean Water Act has another dichotomy, which is the authority is over point sources. There's no direct authority to control non-point sources in the statute. They don't get permits. Basically what it says is that states are to work cooperatively with non-point sources, which means agriculture and stormwater and lots of other sources, to do the right thing. So what happens is there's a lot of fighting between point sources who at the end of the day have to meet that permit, and if they don't, they get assessed some of those penalties that I showed you on the prior slide, versus the non-point sources who might be strongly encouraged to do something to reduce runoff from their land, but at the end of the day, no permit, no penalty. So there's a little inequity in the statute that, again, if it were picked up again and significantly changed, this would be another area, there'd be a big fight over it for sure. But it's definitely a weakness in the statute. And then I'm just going to very quickly say that obviously under any kind of permit you would have to report things. I used to talk frequently with water officials from other countries, and they were so intrigued by our system of self-reporting. And most of our environmental laws have a self-reporting system. The regulated entity puts the submission in the form of something called a DMR, Discharge Monitoring Report. They self-monitor, and they turn that information into the state. That information can be used by the state to bring an enforcement action. That information can sit on a shelf. That information can be called by a bright law student in the PACE Environmental Litigation Clinic and used to bring a case. So all that information is out there through the form of the DMRs. If you are, say, a chemical manufacturing plant, and in your initial permit application, you say you're making methyl ethyl death. And then you decide to make methyl dethyl death. That's a change. It's going to change your discharge. You're supposed to report that. The other thing you have to report is an upset or a bypass. If you have stated to the permitting authority that you are going to treat the water coming out of your plant through, you know, these following treatment units, and you have a malfunction and this treatment unit shuts down and you have to bypass it, then you must notify the permitting authority that you've bypassed a portion of treatment. Doesn't mean that you've necessarily violated your permit, but you have to notify. And an upset would be a similar condition where something goes wrong in the facility and you need to notify.
Or if there's a major storm event, and I think there are different requirements for whether you know about the storm event, or if you know that a facility is going to discharge into your system, and they've had a chemical upset, and they're going to be discharging a different chemical that they don't usually discharge, you need to let the permitting authority know about that as well.
Mm-hmm. And obviously, similar concepts for reopening, any kind of changes, as I've referred to. I've mentioned revocability. Certainly, you know, if you are, and some of you might remember, you know, after the Deepwater Horizon, there was, these weren't NPDES permits, but there were discussion about the fact that the self-regulation of those platforms was a bit of a problem. People were submitting the same reports month after month with, you know, whiteout and just changing the date. They weren't actually monitoring. That's a problem under those laws as well as under the Clean Water Act. Citizen suits, every one of you in this room is empowered, whether you're a lawyer or not, to get yourself a lawyer, although you don't need one, to bring a citizen suit. So if the state is not enforcing against a violator, if the federal government in the form of EPA is not enforcing against a violator, we are all empowered to be citizen attorney generals and protect the environment ourselves. What we need to do, however, is give 60 days notice to the facility that you're going to sue, that you plan to sue them. And in that 60 days, frequently something happens. Usually EPA or the state turns up and says, whoops, we're doing something about this, and they'll send a letter and say to facility, we're not happy with what's going on, and we are starting an investigation. Anything like that will be considered diligent prosecution, so diligent with a small d, and it will bar the citizen suit. So the citizen suit is a powerful tool, but can be sort of knocked away by action by the state or by the federal government.
Mm-hmm. A lot of times, and a lot of you, work for environmental NGOs who often bring citizen suits. Sometimes, as Alex mentioned, EPA and state inspectors just can't be everywhere. It's expensive to go inspect. And sometimes local NGOs have better ability to know which facilities are likely to violate. They can develop sort of a historical perspective on maybe what the major dischargers are on a river, who they know to be known violators, and they can keep great data on discharges and violations, and also have the tools ready to start the citizen suit. And also from a standing perspective, the organizations need to show that they have representational standing, and they're being harmed. They're citizens. They represent people who are being harmed. This is germane to their cause. They protect, say, their sort of watchdogs for a particular river or a watershed, and they can therefore bring the suit. And so it's sort of a backup to the government, and it's a really powerful, very powerful tool.
Mm-hmm. Especially if a citizen group prevails under the Clean Water Act, there are attorney's fees. They will recoup their attorney's fees. And so most NGOs that bring citizen suit litigation, that is an important source of revenue for them. Mm-hmm. Obviously, they're prevailing, they win. That means that they found a violation that wasn't being enforced. So that's good news for the environment, and they will collect their attorney's fees. Also risky if you don't win, right? So, but generally they're pretty successful. I'm going to skip right over this to say, again, I mentioned the SRF. There's also, I mentioned to you the fact that the reason the states take the 402 program is because of this 106, which gives states money to run the permitting program. There's also a very important program called 319, which are grants by states to deal with the non-point source problem that I talked to you about. This morning, my organization sent a letter to the head of the EPA complaining about some cuts in this current fiscal year and next fiscal year to 319. It's already an underfunded program, and we're very concerned about that because of the problems that come from agricultural runoff and non-point runoff. So it's an area that needs a lot of attention. And now I think Erin is in charge of telling you, so we've laid the foundation, hopefully. You've heard some terms, lots of terms of art, lots of acronyms. Maybe we should pause and see if there's a question or two. Anything that we've said that might make listening to the current issues hard to understand, or anything that was confusing or ambiguous? All right, well, you all are too kind. I'm sure there was plenty. But with that, I'm going to turn it to Erin to talk about this foundation that we've just laid, how all of it is still kind of active and being questioned and being challenged and being implemented. This law, while it hasn't been majorly amended in a long time, is about as dynamic as a statute. Well, Clean Air Act too. Most of the statutes right now, they're just busy.
Exactly, and that's, I think, precisely why I really like working with the Clean Water Act, and why if you're working in Washington just for the summer or you're here, you might be hearing about some of these cases and some of these issues that, that come up. And so I want to talk about 4 big ones, and then if we have time, I'll mention some others. But the first is, you may have heard that EPA is currently considering the definition of a water of the United States. And there's currently proposed guidance, which is the public comment period is just about done, which would interpret the scope of the Clean Water Act jurisdiction. Also, some interesting things have come up with the intersection of 402 and 404 permitting, what kind of pollutants are permitted and how. Mountaintop mining is a huge issue. I want to touch on one major case study, but of course there are lots of other issues and controversy surrounding mountaintop mining. And also a couple of cases have been decided within the last 8 to 9 months interpreting what a point source is and how EPA might regulate those. And then if we have time, we might talk about some stormwater, non-point source, we've already kind of touched on that, funding, which Alex has talked about, and enforcement. So the Clean Water Act covers navigable waters, which are defined in the Clean Water Act Section 502 as, very helpfully, waters of the U.S. and territorial seas. Okay, well, we can figure out what a territorial sea is. In the United States, it's out to 12 miles. But what is a water of the U.S.? Why isn't that defined in the statute? That would make everyone's life a lot easier if we knew exactly what Congress had thought. Legislative history tells us that Congress wanted to define waters of the U.S. as broadly as the Commerce Clause allows. And so EPA has defined waters of the U.S. in its regulations. It includes waters that are used in interstate commerce, interstate waters and wetlands, all other waters, such as lakes, rivers, streams, wetlands, the use, degradation, or destruction of which could affect interstate commerce. In 1986, EPA gave an example in a regulation of what is this interstate commerce? How do we know if there's interstate commerce? And they said, well, it might mean that there are interstate travelers, people might be extracting fish or shellfish, might be using it for an industrial purpose. And another commerce link included use by migratory birds. Has anyone heard of the migratory bird rule? It's not actually a rule. It was language that was in the preamble to that regulation, but sort of adopted a life of its own and became the justification for, or as attempted to use as a justification for a jurisdictional water under the Clean Water Act, which we'll talk about in just a second, the Swank case. But getting back to what EPA says in its regs, are waters of the U.S. also include impoundments of a water of the U.S., so perhaps a dam, building a dam or a berm. Tributaries of any waters that I've mentioned. The territorial seas, that one we've talked about, that's pretty easy. And wetlands adjacent to the waters that EPA says are jurisdictional. And the adjacent wetlands was confirmed by the Supreme Court in 1985 in a state called Riverside Bayview Homes in a unanimous decision. So that seems pretty settled. And Clean Water Act jurisdiction seemed pretty settled until 2001 in the case of the Solid Waste Agency of Northern Cook County, or SWANC, versus the U.S. Army Corps of Engineers. and then was further complicated in 2006 by two consolidated cases, Rapanos versus the United States and Carabel versus the United States, which called into question the scope of the waters protected under the Clean Water Act, and made it very uncertain which waters could be protected, and which water, it drew even more confusion, which waters are under federal jurisdiction and which waters can states pull into their own jurisdiction if they're not covered by the Clean Water Act.
And maybe just a comment on Swank, because you think, what would the Solid Waste Authority of Northern Cook County have in this? Well, it's really interesting. Okay, that's the suburbs of Chicago, and the county purchased a large area of land that they wanted to use as a landfill in the future. Right? Mm-hmm. So they bought this sort of, it was an abandoned kind of like mining gravel area, but their whole purpose in purchasing this was future garbage dump, okay, for the county. No problem. Well, future, unfortunately in that time, what happens to abandoned mining areas or gravel pits? They fill up with water and, you know, grasses grow, and then lo and behold, all these birds start flying there and coming to visit, and maybe some birders come and they're taking pictures and they have their binoculars, and so Cook County suddenly, you know, the time has come, they need the landfill, and you know, they're going to drain it, right, so that they can start using it as a landfill. And the Army Corps of Engineers says, "Whoa, wait a second! This is a water of the U.S.
Can't do that without a 404 permit.
Need a permit." That was what the litigation was all about.
Exactly. So the outcome of that was that migratory bird connection was not sufficient to show that there was interstate commerce. And the court basically said that waters that are isolated, waters that are by themselves within state boundaries, because remember the interstate waters are jurisdictional, they need to be connected somehow to a river network or streams, and also there needs to be more than just that migratory bird connection for it to be jurisdictional. Otherwise, the Clean Water Act can't reach them. And so filled up ponds in a landfill site where some birds nest, okay, maybe one of those cases you might say that doesn't really sound like a jurisdictional water. But what if you consider that many of those so-called isolated waters aren't really isolated at all, because as we know as environmental professionals, everything's connected to something. You don't have water truly in isolation by itself. Many waters play important roles in maintaining that chemical, physical, and biological integrity of the waters, which is the Clean Water Act's primary goal. So then how can we say that any water is truly isolated? And actually, since that decision in 2001, the government has never said that any of those isolated waters are jurisdictional, unless they're also traditionally navigable. So fast forward to 2006. And the scene gets even more complicated with the Rapanos case. And again was a case where wetlands were being filled in violation of 404 permits.
Mr. Rapanos was a bad guy because this was a criminal case, because he was told several times to get a permit, and he just said, no.
Nope, don't have waters here. And the court was just as confused as we all are now. The Rapanos, I won't even say Rapanos opinion, because there really isn't, or Rapanos decision, because there really wasn't a decision. There were 5 opinions, with none of those having the majority of votes. So we talk about a few of those opinions in this context now. First of all, the Scalia's decision, or the plurality, said that, well, a water might be jurisdictional if it's relatively permanent, or if it flows at least seasonally, or if there are wetlands that have connections to those seasonal or relatively permanent waters. Whereas Justice Kennedy said, well, that might not be the case all the time. You might need, for a water to be jurisdictional, you might need something called a significant nexus to navigable waters, meaning that they're somehow connected biologically or chemically or physically to the downstream traditionally navigable waters. Significant nexus is also not a scientific term. It's something that is court invented, and we now have to figure out how to do that sort of analysis. Because there was no controlling opinion, the government has said in most litigation that either the plurality Scalia opinion or the Kennedy opinion could be used. And only in the 11th Circuit is just Kennedy the standard. So whereas the effect on Swank was on those isolated waters that seemed not to have a connection to other traditionally navigable waters, the effect of Rapanos has mainly been on small streams or headwaters, waters that flow only part of the time but are really critical to eventually providing water and water supplies and providing habitat. They might contribute very much to maintaining water quality and actually form the majority of the stream network in the United States. So they're really essential to protect. And with inconsistent or questionable significant nexus analyses might be really vulnerable.
And just in practice, who's making these significant nexus determinations? As Aaron mentioned, it's the Army Corps of Engineers that makes the decision in most cases. And in each state, the Army Corps can have 5 or 6 Corps districts, right? So with different staff. So you could be in the state of, Texas, and I don't know how many Corps districts there are, but be getting completely inconsistent decisions even within a state. Oh, this little seasonal stream is jurisdictional. Oh, this one over here is not. And so since Rapanos, there's just been really disorder, frustration, I won't say paralysis because projects are going forward, but just it's been really, really difficult for people to know what to expect, whether they're a developer that wants to build something, whether they're a landowner that wants to change something, whether they're a farmer that wants to do something. There's a lot of uncertainty.
Yeah, and also with all those waters that need to be analyzed for significant nexus, it becomes a resource issue too. The Army Corps in conjunction with EPA will, if there are resources, go out and do a site inspection, and there's a form that you have to fill out that the Corps district has to fill out when they make that jurisdictional determination that says, yes, this is a water of the United States for these reasons, because I see that it's connected to such and such a stream, and I see that there are adjacent wetlands, and but oftentimes there aren't enough resources to go out and do that field study. So some of those jurisdictional determinations are made using Google Earth from your desk. So not ideal, but when possible, of course, there is that on-site analysis, but there are just so many that need to be done because of the confusion wrought by Rapanos.
Right.
Another thing that I want to mention is that there's one definition of waters of the United States for the entire Clean Water Act. We've talked about 402, now we're talking about 404, and so it's really important that the geographic scope and the legal scope of what a water of the United States is consistent. It also influences the Water Quality Standards Program, the Section 311 oil spill program and cleanup. And so it's really critical that we have a unified definition of waters of the United States that's based in law and science. So the agencies have been interpreting what a water of the United States is ever since Swank and Rapanos were decided. There was a guidance put out in 2008, which helped the situation, but there's still some confusion. And so right now the agencies have out for public comment a proposed guidance which would hopefully clarify the historic scope of the Clean Water Act. And as I said before, the comment period is closing, so the public, in the spirit of public participation in our regulatory development, has that chance to influence that. As right now, as proposed, and you can see this on EPA or Army Corps websites, and there's been a lot of press about it as well. that traditionally navigable waters, interstate waters, adjacent wetlands would all be jurisdictional. And
So far, that's consistent with past.
And tributaries to the traditionally navigable waters that aren't themselves navigable, but are relatively permanent or seasonal, so that you hear a little bit of scalia coming in there. And also wetlands that directly abut relatively permanent waters. If there's a significant physical, chemical, or biological connection between a water body that is connected to a traditionally navigable water, both water bodies would be protected under this guidance.
And all of this is now take it, anyone from like Arizona, Utah, yeah. I mean, so think about it. This whole concept of like seasonal water bodies, relatively permanent water bodies, not really a big question in a lot of parts of the country because people kind of know what's wet and when it's wet. But there are parts of this country where things are wet rarely. And what does seasonal mean? Are we talking about every spring, or when there's certain size flood events or certain heavy rains? So as an organization of 50 states that is attempting to provide the EPA our comments by July 1st, you can imagine trying to wrestle with the fact that something so fundamental, if anything has come across in our talk, is that we've got to figure out what is a water of the U.S. or the statute just sort of falls apart, is incredibly complicated and very political because states have a lot of strong feelings about what they should be in control of versus what maybe the Army Corps and EPA should be doing.
Under the proposed guidance, some other waters would now be subject to the significant nexus analysis, and the guidance explains how that would be done. And these include tributaries to traditionally navigable waters, wetlands adjacent to the tributaries to the TNWs or the interstate waters, and also waters that fall under the other waters category. Remember, we talked about those waters that were swanked, I guess. The isolated waters, which didn't have a connection, you would look at them in terms of what does the whole watershed look like? Where can we find those connections? Remembering that from a scientific point of view, there may be ways to look for connections that the Supreme Court didn't think about initially. The proposed guidance, as proposed, doesn't change what the agencies have called non-jurisdictional. Certainly there are waters that are not tributaries, they're not wetlands, they're not open waters. Waters might be excluded by regulation if you the EPA and Army Corps' regs say that things that aren't waters of the U.S. include prior converted cropland, so wetlands that you had been using as cropland. If they return to being wetlands, they're not jurisdictional. And if you have a waste treatment system, if you impound a water of the U.S. to treat wastes before then those wastes are released into another waters of the U.S., that would also not be jurisdictional. The guidance can't change those and doesn't change those. If the water just doesn't have a significant nexus under the guidance, then that's also not jurisdictional. Things like lakes, ponds, bird baths, ornamental waters, areas that are artificially irrigated are also still not jurisdictional. Erosional features like gullies, still not jurisdictional. And also it doesn't take away any of the agricultural exemptions under the Clean Water Act. The guidance can't do that, it's guidance.
Right. And just to give you again a bit of the flavor, people will joke, well, if EPA has to say that a bird bath is not a water of the U.S., that shows you how many things they do think are waters of the U.S. That's one way to look at it. I've heard from the counties. So you've got the counties out there all over the United States, and they have these ditches on the sides of roads that fill up with like vegetation and like kind of mucky water after rain, and they want to go through and clean out those roadside ditches. The U.S. counties are asking questions about this guidance to say, well, would we need a permit to go clean out a ditch on the side of a county road that has some vegetation and water in it? And probably that ditch is ultimately somewhere down the road connected probably to a stream, and would under this probably have a significant nexus. So there's sort of like these practical questions that folks are raising. I mean, in one sense you say, yeah, if you're a county and you need to go clean out your ditch so it drains properly, that makes sense, but then you're gonna maybe have to get a permit for that. And what would the permit tell you to do? It might tell you to minimize how much vegetation you take out, or do it only at certain times of the year when there might not be little minnows in there. But these are the kinds of questions that are being asked by different groups.
Definitely. And as we kind of near the end of our conversation about Clean Water Act jurisdiction and what a waters the U.S. is, does anyone have any questions at this point before we move on to another topic?
What about stormwater retention ponds? If that's out, or?
Yeah, that would be
No,
waste
that's-
treatment, waste treatment. And that's a
sure. The question was, what about stormwater retention ponds and whether those would be jurisdictional? And I think that
It's not addressed explicitly in the
Yeah.
guidance, but we have understood from agency representatives that clarification will be made, that stormwater systems are not waters of the U.S., although there have been court decisions that hold contrary. So good question. Probably a complicated solution.
yes.
I had one. I was just curious, did you say the 11th Circuit is the only one using Penalties' opinion? And if so, is there a reason that the significant nexus language is still in the guidance? Are they supporting that language?
Sure. I'll repeat the question. The question is it true that the 11th Circuit is the only circuit that uses Kennedy's opinion? And if so, why do we talk about significant nexus in the guidance? And that's a great question. Let me just clarify that 11th Circuit decision, the McWane decision, uses only Kennedy and doesn't consider Scalia. Other circuits consider both. And the government has used both arguments in briefs and in litigation. And so it's worth clarifying for those circuits that use one or either, for those circuits that use either, and for the 11th Circuit that uses just the significant nexus Kennedy analysis, what we really mean by that.
Is this up for public comment right now?
That's correct.
What does that mean exactly? Does that mean town hall meetings? I mean, how public is the public?
It's my
Who's involved?
Sure. The question was, is the guidance out for public comment, and what does that mean? And again, I want to reiterate that my opinions here and what I'm telling you is my opinions as Erin Flannery and not as Erin Flannery EPA. But as a citizen, I would want to know about that too. And as you'll see on regulations.gov, the comment period ends on July 1st. And people have had the opportunity to send in written comments. It's also my understanding that there's been consultation with tribes and different organizations that are interested in this, and so there have been some listening sessions and other opportunities to submit written comments and feedback.
And the day that Administrator Jackson announced its availability, the agency held a series of conference calls with different representational groups like states, governors, industries,
environmental NGOs, environmental justice organizations. Okay. So you've heard about how the Clean Water Act has two big permitting programs, the Clean Water Act Section 402 NPDES program and the 404 program. And recall that 402 is administered in 46 cases by the states, in 4 cases by EPA, and the 404 permit program is administered by the Corps of Engineers with EPA oversight and participation, except in 2 cases. And they're those permitting programs are mutually exclusive. We're talking about different kinds of pollutants. Alex talked a great deal about point sources and how if you can point to it, then that's a point source. And we often think of the kinds of effluent coming out of those point sources as very liquid in nature, wastewater. And then the 404 permit program deals with waste that's more solid in nature, and that when put into a water of the United States could actually change the bottom elevation of waters in the United States. But surely there might come a point where that solid material that you're putting into a water might have characteristics that are harmful to waters, and you might wonder how they could be permitted under the 404 program as fill when they actually have properties that EPA would like to control under the 402 program. So let me give you a case study. In Alaska, in Tongass National Forest, there's a lake called Lower Slate Lake, and there's a lot of hard rock mining that goes on in Alaska. Gold, copper, molybdenum, other minerals that large companies mine and often open pit mines. And they go through various waste treatment processes, which often end up producing a waste that is sort of liquid in nature and sort of solid in nature. In fact, it could be so solid in nature that when you put it into a water of the United States, it might change the bottom elevation of the water of the United States. So that starts to sound like fill, except if it's in the form of a slurry, that sounds kind of liquid. So what do you do? Well, the Kensington Mine Company in Alaska was applied for and was granted a 404 permit to discharge mine tailings into Lower Slate Lake in Tongass National Forest. And an environmental group in Alaska sued saying, wait a minute, sure, this looks like fill, it's changing that bottom elevation, but EPA has also developed an effluent limitation guideline for this very kind of mining that you're talking about here, this ore dressing and mining. This was a gold mine. Shouldn't this mining company be applying for a 402 permit to discharge? In which case, EPA, your effluent limitation guideline for this particular industry says that this new source shouldn't be discharging at all. They should have a zero discharge. How can you say zero discharge on one hand and fill up the lake in the other hand? That's pretty confusing. Now those effluent limitation guidelines, or ELGs, were developed for industries with a purpose. Alex talked about that a little bit before. If you're a particular kind of facility, there are particular pollutants that you should be that the public should be concerned about getting into their water supply, and so those effluent limitations should be put into your 402 permit. But there's great ambiguity there because of the separate nature of those of the 402 and the 404 permitting programs, and because certain kinds of mining waste had always been treated under 404. So in this litigation, the parties agreed that the tailings they met the definition of fill material, but that ambiguity existed because EPA also regulated this kind of chemical discharge from such a mining facility under the effluent limitation guidelines. And the Supreme Court said, well, this is very ambiguous. Your fill rule is ambiguous. And the agency had also interpreted their own rule to say that these kinds of mining wastes were 404 fill and not 402 wastewater. And so that the permit should be a 404 permit, not a 402 permit. And the Supreme Court found that this is all very ambiguous because these these permit programs are mutually exclusive. The 404 permit was appropriate, and the Corps of Engineers had properly issued that 404 permit. So what do you do? What do you do when you have two competing programs? I suppose that the opportunity would exist for clarification, because it might seem to some that you might mining waste that is solid and raises the level should be fill. Others might say, well, if EPA was so concerned about it back in the 80s when they developed this effluent limitation guideline, you should be using that. So stay tuned for more information about how these permit programs interact with one another in the future, not only in the mining context, but other wastes that might have the characteristics of both. I mentioned before that lots of you have probably heard about mountaintop mining, and mainly think about it in the context of Appalachia. Mountaintop coal mining is surface mining that involves removing mountaintops to expose coal seams and then depositing what's left into the overburden, depositing what's left into adjacent valleys, which are called valley fills. And you mainly see these in steep terrain where there are very limited disposal alternatives. And mountaintop mining operations right now are concentrated in Appalachia, eastern Kentucky, southern West Virginia, western Virginia, and certain areas of Tennessee. When you put such overburden into valleys in mountainous areas, those valleys often have streams. And so these valley fills may cover and bury streams. They might increase the concentration of minerals and pollutants in water, which might affect fish and wildlife and drinking water. You might fragment forests and impair the regrowth of trees and other vegetation. So in order to deposit this material into a water of the United States, you need a 404 permit from the Army Corps of Engineers. I mentioned before that there's this balance of authority between the EPA and the Army Corps of Engineers when it comes to Section 404. Section 404C of the Clean Water Act gives EPA the authority to prohibit, restrict, or deny the discharge of dredged or fill material into waters of the United States and wetlands. When EPA determines after notice and comment, public hearing, and significant analysis that the use of this particular site will cause, and the term is unacceptable adverse impact on one or more various resources, including fisheries, wildlife, municipal water supplies, or recreational areas. And the bar for this is extremely high. It involves a significant administrative record, public hearings, the review of tens of thousands of public comments. This bar is so high, perhaps, that
It's rarely been used.
Rarely been used, only 13 times since the beginning of the Clean Water Act. But the most recent 404C determination by EPA was done in January 2011 at the Spruce Mine in West Virginia, where the Corps had authorized 6 valley fills, which I had just described, depositing that mining waste into tributaries of the Coal River. And it's one of the largest surface mining operations ever authorized in Appalachia and the largest in West Virginia. The watershed had been previously impacted by mining activity. And the sedimentation from these valley fills was impacting particular branches of the Coal River. All in all, as designed, the mine would bury 7 miles of streams and cause other cumulative impacts. And so EPA announced that it would use its 404C authority to first do a proposed determination, then a recommended determination, all the time building that administrative record, and finally a final determination, which came in January of this year. Now, I mentioned that authority had been used only 13 times, counting Spruce in 2011. A bill was introduced in Congress, in the House, in late May, H.R. 2018, which would constrict EPA's ability to use that 404C authority. In fact, it would require states to concur with the regional administrator who would find that a permit would have unacceptable adverse impacts. So EPA wouldn't be the only entity anymore saying that the project would be vetoed.
Well, just maybe a commentary on sort of the politics of this. The bill was introduced and called a bipartisan bill, but it was introduced by the Republican congressman from West Virginia and a Democratic congressman from West Virginia. So it was bipartisan, but from the same state, because frankly, you know, that state has, you know, very difficult economics, and, you know, mining is a very important industry in this state. So the bill was presented as though, you know, it had this bipartisan support, and it was called the Clean Water Cooperative Federalism Act of 2011, which cooperative federalism, as I told you back in the beginning, is one of the foundational concepts of this law, and it's a nice way to kind of bring us full circle for this talk, although I know we have a few others, but I'm watching the time too, in that, you know, it's a balance between states and federal government, and here, the folks in West Virginia, particularly the members of Congress, the coal industry, none too happy with this objection. And so the bill would amend the Clean Water Act to essentially, as Aaron mentioned, take EPA out of the picture completely, but not only in this scenario, but the bill is quite broad and would actually take EPA out of the picture in a whole number of other scenarios, such as approving state water quality standards, approving other actions by states.
Yeah, including
TMDLs.
withdrawing programs, NIPTES programs.
Right. So the question is, where we are in environment today, and especially in clean water, it's so political that there may be a real need for a better conversation between the folks in West Virginia and EPA Region 3 and 4, which are both involved in this area, and maybe headquarters, and we've got questions about what is fill and what's an unacceptable adverse effect. But you get Congress coming and saying, well, we're just going to amend the Clean Water Act and, you know, and sort of take EPA out at the knees and you know, fix this horrible imbalance between the states and the federal government. And it's unfortunate because a really good conversation around these issues can't be held in that kind of environment. The bill was marked up yesterday. I watched it streaming online, and I think it's still there in House T&I. It's a very interesting thing to watch because most of the members of Congress asking questions, you can tell that they don't know much about the Clean Water Act. They're asking questions that, frankly, are just not relevant. The whole markup was sort of odd, and because the Republicans are in the majority, it passed 35-20 out of the full committee, and likely will go to the House floor soon. But politics are everywhere in water today.
Absolutely, absolutely. And a lot of times, as Alex mentioned, what's at stake are jobs and industry, and how do we balance a vibrant economy and keeping industry going with these very real environmental concerns. One such topic I wanted to touch on briefly is the issue of logging roads or forest roads, another key industry in our country, but one that could potentially harm water quality. So the Clean Water Act, as we've discussed, requires NIPTES permits for point sources for discharges to waters of the United States, but non-point source pollution, as we've also talked about, is not subject to the same requirements, usually addressed through a TMDL. And there are some statutory exemptions for NIPTES permitting, and there's a silvicultural or forestry exemption within EPA's rules for NIPTES permitting. Basically, the silvicultural rule said that timber harvesting operations, surface drainage, road construction, or maintenance from which there is natural runoff is non-point source. However, a recent Ninth Circuit case, the Northwest Environmental Defense Center versus Brown, called that into question, and it suggests that logging roads are point sources subject to NIPTES permitting. So that would mean the EPA would have to regulate a whole new industry and come up with a permitting process for that. The NEDC sued the Oregon State Forester, the Oregon Board of Forestry, and several lumber companies that leased road rights from the state with state contracts, saying that the NIPTES permits were required for the stormwater runoff from forest roads, because the sediment produced from those roads was then put into culverts on the sides of the roads, made the stormwater really turbid, and then discharged into waters of the United States. And the plaintiffs said that this was industrial activity that was subject to EPA's stormwater NIPDES requirements, because NIPDES stormwater Phase 1 requirements require NIPDES permits for industrial activities under Section 402P. In the district court, the defendant's motion to dismiss was granted, but the Ninth Circuit reversed and said that the silvicultural rule couldn't exclude logging road discharges from NIPDES permitting because they were industrial stormwater discharges, that if it was a point source, it was a point source, and EPA couldn't exempt that. They need to regulate all point sources. So logging roads may be industrial dischargers. Recently, in late May, the petition for rehearing en banc in the Ninth Circuit was denied. The parties may petition for cert, so stay tuned for that, and for any other cases where litigants may be saying that something is a point source that EPA should be regulating, or if an industry is saying, no, keep us as a non-point source, we're doing fine already.
Mm-hmm. And you know, in sort of conclusion, that the challenge here is what makes a forest road different from any other kind of road? So if a forest road with culverts and channels designed intentionally to manage the stormwater, it's a best management practice, is if that's what you want that done. But if that makes one a point source and you have to get a permit, then almost you would think, well, then why build the culvert, right? Why manage the stormwater properly? Because all of a sudden I'm going to get swept into this program and I'm going to have to meet all these owners' requirements. So it's almost, again, the courts are playing a big role in this, and the courts are able to just like in Swank and Rapanos and even the NEDC case, kind of look at something kind of narrowly and say, well, this is a point source and it's a navigable water and it's discharging pollutants, and here's our holding. And then the EPA and the states are left going, oh, okay, now we have forest roads, and what about highways? What about other roads? What about all state roads? I mean, what, do we have to now have a permit for all runoff from all roads? And so it's interesting to see the courts playing such a big role in the Clean Water Act, and a lot of it is because Congress has not played a big role in the statute trying to clarify some of these legitimate areas that need clarification. And so we end up with very fractured approaches to the statute that challenges, I think, EPA in a lot of ways to try and make sense of them, like they're trying to do with a non-opinion from the Supreme Court, to one like this. The other issue that comes up is how broadly do you apply these decisions? This is a Ninth Circuit decision. Those of you who follow courts know the Ninth Circuit's a very progressive court. They tend to lean and come out generally, you know, more in favor of some what you might call a pro-environmental result. But that holding technically only applies in the Ninth Circuit. What does EPA do with that? Do they apply it all over the country? The general approach is to yes, because what you can't, the whole point of the Clean Water Act is to have a consistent system. And so some of these decisions that are coming out of particular parts of the country then get picked up, and we have to find a way to make them work nationally.
Yeah, it would be very difficult to say, okay, well, the silvicultural rule has no continuing effect in the Ninth Circuit, so we're going to treat that separately and differently from the rest of the country. And similarly, the Fifth Circuit, just really quickly, has recently called into question EPA's 2008 CAFO rule, and the Fifth Circuit recently said that the Clean Water Act doesn't include a duty to apply for a NIPDES permit if you only have a proposed discharge or a potential discharge, that this duty doesn't attach until the discharge actually occurs for CAFOs. But I see the problem there being that some dischargers, especially new CAFOs, have to meet the effluent limitation guideline of no discharge at all. And so it's almost like you come into this circuitous logic of, well, the no discharge, zero discharge limit would be in their permit, and only if they don't discharge would they be in compliance with that permit. So you could argue that a CAFO would need a permit even if they didn't plan to discharge, because not discharging would be the only way to comply. But maybe from the point of view of the industry, they want to take a business risk and say, I'm not going to discharge, so I'm not going to get a permit and take that risk. But I think that kind of calls into the question the Clean Water Act's precautionary approach in general, in trying to prevent discharges from point sources and into waters of the United States, and not wait until that harm occurs to deal with it.
So I think we're pretty much at our time, Rebecca, just about. Oh, we have till 2. Okay, so we have time maybe for Q&A. And, you know, we could talk forever about most of these things, but I don't think you all would want that. So why don't we open it to some questions, and anyone on the web, I think, could email mcmurrin@eli.org and send a question in. So we'd love to hear from you as well out there in internet land. So any questions in the room? Yeah.
Yeah, a question about the 404 bill permits. I mean, I was under the impression that the Army Corps had to have some sort of, I mean, I assumed it had to be some sort of like so-called clean bill of some sort. But if they're allowing slurry, I mean, what is the purpose of the Army Corps permit? I mean, other than protecting navigation, I understand that part of it, but beyond that, if they can use slurry as a fill, I mean, what are they doing? What are the requirements of those permits?
Sure. To repeat the question, Amber was asking about whether, like, what's the purpose of a 404 permit, and if you can deposit something like a slurry, why do that? Why are they allowed to? Why is someone allowed to do that when the fill is not clean? You know, the effluent limitation guidelines that EPA develops under Section 306 are only applicable to Section 402 permits that are given by EPA. The Corps doesn't have analogous effluent limitations or fill limitations where they're, you know, chemically calculated to limit that.
The Act doesn't put any requirements as far as
Well,
how the Corps has to.
if you need to make sure that that your action of filling a water of the United States is going to have the least environmentally damaging impact. So there is an analysis, there is an alternatives analysis that goes on within that permitting process. And if you cannot do your project without filling this particular water and filling it in this particular way, you need to avoid impacts, you need to mitigate those impacts and compensate for those impacts. So it's a different kind of analysis when you put fill material into waters than it is when you put other effluent in. So there are protections, it's just not the same protections. And I wouldn't say that one is better than the other, they're just different.
And I think that's, again, when you think about a statute that's coming up on its 4th decade, it's sort of this evolution. I mean, in the early days, just controlling fill, just managing that process was a step forward for the environment. You might not even get to those questions of the quality of the fill and so forth. EPA has that sort of environmental protection mission. The Army Corps of Engineers, they build things and are more sort of navigation oriented. But now as the statute has matured, you get a case like the one that Aaron talked about in Alaska that's kind of sort of starting to ask these very questions. Well, wait a second. And back in '72, you know, was this what Congress was thinking about? Probably not, because they couldn't have been thinking about these kinds of things back then because the nature of the problems were so different. And that's why you see so much analysis of this statute today and sort of questions being asked about whether and why these cases are being brought, because the cases are almost like an example of the real challenges and limitations of the current law, and pushing it a little bit to say, wait a second, is this how it should be? Mm-hmm. Because it doesn't seem like it's the right outcome. Good question. Any others? Yes.
Question on the logging road. with that, decision, did they have any discussion about shared roads where industry is maybe creating a road and there's a cost share agreement with some other kind of, we work for the Forest Service and we do cost share roads where the road is used for management of the forest plus civil culture. I was wondering if there was any discussion if there had to be a primary purpose or.
I don't.
Sure.
The question is whether in the Brown case there was discussion about shared roads that are used both for I guess a private industry or private company and say the Forest Service, like a governmental purpose. I don't know the answer to that, and I'm sorry.
I mean, it's kind of follow-up question is permitting going to be issued only for new roads or for road maintenance as well coming up?
I don't think that's known either.
Okay.
Yeah.
This is new territory for EPA and for states that would be permitting these. So that's why it's something that's really exciting to watch, and especially, we don't even know what would happen if the Supreme Court decides to grant cert on this.
Yeah, and at the rate they've been going, maybe we should hope they don't, because
The
who
Ninth
knows
Circuit
what they would
gets-
do with
right.
with the definition of point source.
Right. The Ninth Circuit in the Core Alaska case had said that the 402 permitting scheme was more proper, and then the Supreme Court reversed them.
Yeah.
I'm just wondering where is EPA at implementing this? Are you holding off to see if there's an additional appeal? Or, I'm a reporter, but I've just been here, learning. But so,
Right. I'm not speaking in my official capacity, so I can't say, and I also am not sure if what's being planned. Sure. The question was how EPA was planning to implement permitting for forest roads, correct?
what would be the challenges? That's another question.
I know it's something that the states have looked at as well, and I can say that I don't believe EPA has decided how it's going to go forward because of the continuing appeal and the complexity of the issue. I'm not speaking for the agency either, but that's what I've heard. Yeah. Yes.
I was wondering if the Section 402 in the NEPA's permitting was flexible enough to allow for a regional nutrient trading program where a point source pollutant could buy or exceed his phosphorus, effluent concentrations and offset it by an upstream fluid going below his normal concentration.
So the question is whether 402 is flexible enough to allow point, non-point trading and pollutant trading. And that's a great question because there's a lot of trading going on, especially where you have a TMDL, where you've got sort of this fixed assimilative capacity of the water body and you have to divide up that pie. And an industrial facility might be able to control and reduce additional pollutants, where another party in that same water body can't do that as cost effectively, and they can work out agreements between themselves. Those agreements tend to not be implemented in the NPDES permit themselves. They tend to be outside agreements. And there are pretty serious legal questions about accountability because at the end of the day, the permit holder is going to have to meet those requirements. And so if a permit holder is relying on a trade or an offset from another party and that other party fails to do that, there's no way to shift that liability off the NPDES permit. So, so if the question is the flexibility of NPDES, not so flexible. Is there a lot of trading going on? Yes, there is, and there's some really successful models in the Long Island Sound, Chesapeake Bay, Neuse River in North Carolina, so forth.
I guess what I was more interested in was on a regional scale. There's a lot of them are within a state trading TMDL credits or however we use it from one state to another. Some other state.
Let me think about it. In the Long Island Sound, the trading program is all Connecticut POTWs, I believe. I don't think there's any cross state trading. I would have to do a little bit more research, but I worked on trading for a while, and at the time it was mostly in-state. Even in the Chesapeake Bay, which is broad, I don't know if there's concept of interstate trading. I think it's would be new territory, but you're raising a great issue. That's another area where, as you hear, the whole concept of significant nexus is that all water is somehow connected, right? And so, if it really is all connected, why can't we have these cross-border trades and do some more regional control? Great question. Others? Yes.
Since this is about the Clean Water Act, I thought we could take a few minutes to talk about how that fits in with other regulatory regimes, regulation of groundwater, Safe Drinking Water Act. And I also had sort of a broad question about regulation of water quality versus any sorts of rules about regulating water quantity, because now we have issues arising with the droughts, with the use of water for mining. How can that be addressed in a regulatory fashion?
Well, I can take the quantity quality one initially. So interestingly, in 104G of the Clean Water Act, there is a sort of reservation of rights to the states to allocate quantities of water within their boundaries. And so water quantity is viewed very much as a state issue. However, you can have TMDLs for flow. So think about it. Flow, the quantity of water in a stream, can impact the biology and the aquatic habitat and the even availability to fish or swim. And so there is a crossover between quantity and quality in that area where a discharger in the 402 permit could be required to maintain a certain amount of flow. You also may have in cooling water intakes, which is a different provision, issues about how much is being pulled out because of the volume of water being impacted. So quantity and quality are colliding more, and for example, lots of conferences in the past like 2 to 3 years on like cutting edge water issues are about quantity and quality meeting because that's sort of the new trend. Maybe you want to take the one about the statute and its structure and other regimes.
Well, yeah, sure. Oftentimes, people initially with their first blush at the Clean Water Act and water law in general wonder why the Clean Water Act doesn't regulate drinking water or groundwater. And I guess it just doesn't. There's a Safe Drinking Water, the Federal Safe Drinking Water Act, which is also housed in the Office of Water EPA, but a different part. And sometimes those issues are sort of stovepiped, and we don't think about them in concert with one another, even though perhaps we should. And so the Safe Drinking Water Act also has underground injection control language, what sorts of chemicals can be put into the ground, but the Clean Water Act itself doesn't regulate drinking water. But we've also been talking about, and Alex just mentioned again, that water is all connected. You can't say that what you do with groundwater won't affect surface water. In fact, remember earlier I mentioned that a lot of the headwater streams in different areas that were called into, whose jurisdiction was called into question under the Clean Water Act, do supply a great deal of our source waters for our drinking water. And so perhaps protecting those headwaters and source waters under the Clean Water Act would help to improve the quality of our drinking water. States also have the ability to say what a water of their state is. And in many cases, a water of a state will be something different than a water of the U.S. If the Federal Clean Water Act can't protect it, maybe a state statute or regulation could. And some states say that their waters of the state include their groundwater. So there are extra layers of protection there.
Mm-hmm. Great. Well, thank you all very much for staying to the end.
Yeah, thank you. And I just wanted to let people know next week on the 28th, we're having a seminar here, same time, to talk about the guidance. So.
Oh, good.
And That's actually a members event, so that you pay a fee if you're a member, but I wanted to point out also that for students, ELI membership is free. So you can become an ELI member. We have seminars like this all year round. You can attend by teleconference. And
we got some questions for the web.
Questions, so
Good.
I'll let you decide if you want to give them a quick look.
Okay.
All right. Maybe it looks like maybe we'll each take one. Oh, this is great. So just what a commentary maybe from a state regulator in Tennessee, former state regulator, former deputy commissioner, in fact, in Tennessee, indicating that the Tennessee does not permit valley fills that bury state waters, and so they have none of the mountaintop removals issues that were alluded to, and that Tennessee has a Responsible Mining Act which requires buffers around streams not previously mined. So a bigger picture commentary from this is, and it's always important, it's not just federal law, and Erin frankly just alluded to that with her reference to state definitions of water. There could be state requirements, as this gentleman is wisely pointing out, that also play in. So a lot of the tension in the area is about, are states green lighting more? Are they restricting? Do they have the resources to do this? It sounds like from here, some good requirements in Tennessee. There are different levels of confidence in the states and their abilities and their resources, different levels of confidence in the federal government. But this is a great point that there would be state law, at least in Tennessee, that might restrict some of that valley fill. Mm-hmm. What did you get?
I have a question that mirrors a question that we had before, so I think it's just a good chance to reiterate. The question is, when the Corps issues a 404 permit, is it just a yes or no decision, or can it impose limitations on how much fill, the content of the fill, or other limits? And I do want to reiterate that the applicant would need to show that their particular fill project would be the least environmentally damaging practicable alternative, or LEDPA. And under the 404B1 guidelines, which are in Corps and EPA's regulations, you do have to do a rigorous alternatives analysis. Can you do your project in uplands? Do you have to impact water at all? Do you have to impact this particular water? Can you have a smaller footprint for your project? And so proposed permit might change, the form of the project might change or be altered. They might put conditions on permits. They might put particular mitigation requirements on permits so that you compensate for the loss of the water or wetlands that you have.
Right.
Thank you very much. Stay tuned for our other summer school sessions, but I really want to thank you for your incredibly informative presentation today.
It was a lot of fun. Thanks for sticking us out.